over to our panel online. And I'll invite Anna to come up to the stage to introduce them in detail. But we're delighted to be joined by Robert Spano, the former President of the European Court of Human Rights, Pusetso yes, and there they are. We're Kieran from the Human Rights Centre in Australia, Pusetso Morapedi from South Africa, Platform to Protect Whistleblowers, and Devine from the Government Accountability Project. I will hand you over to our capable chair, Anna, who's our only person here in person, and welcome to our team from around the world.
I know Spam is very odd to me. I'm often the only person not in the room, not the only person in the room on this panel. I'm very excited to be here today. I think one of the small stories behind Wen is that having been trained as a lawyer in Canada, and even in the largest common law bar outside of England, when I came I understood that understanding what the law meant was one thing, but advising people day in and day out on a advice line about what they need to throw is much more powerful. And I was still powerful in this country and in Great Britain and the United Kingdom. But it also then really set the scene, I think, for me, because when we were looking at public tech, we were contacted by NGOs, new civil society initiatives who were interested in what we were doing, how we were shifting. As parliamentarians, so there. And there was a book that was a guy Dane. Sometimes the laws will how you approach
this.
I will be able to speak eloquently on what we talked about in the UK was good governance and better regulation, really as a way to open the door. In other parts of the world, starting with human rights is really important. And I thought with these four eminent guests, we might start with them giving an idea of what they think is happening in their area of expertise. So Robert Spano, who is an eminent jurist and was president of the European Court of Human Rights. Turn on the lecture on the LA case, which is one of the most recent and is the most recent and important decision out of the European Court of Human Rights, but also looking at the jurisprudence of the European Court of Human Rights over time. The fact that we now have an EU directive to protect whistleblowers, which obviously covers 7 EU member states, doesn't stop the court from having a view from a slightly different perspective, obviously taking into account. So I would really important to hear from Robert. And once I hear from Robert, I'd like to move to Pusetso. She's there. I haven't seen her face yet, to talk a little bit about the South African experience, as well as the African experience. She's also in Botswana, because there as well the human rights and freedom of expression, Article 10 rights are important for the whistleblowing agenda. And then I'd like to move to Kieran to find out what's been happening in Australia. Kieran Pender, again, but Kieran, just very briefly, Pusetso is with the Platform for la Protection des lanceurs d'alerte en Afrique, the PPLAAF. So that's the Protection for African Whistleblowers platform. And she's their Southern African director. And she's also been doing work in Botswana, where she is from. She is the board secretary of the Botswana Center for Public Integrity. And moving then to Kieran Pender, who was with the International Bar Association at the time that we were doing a lot of work on the EU directive. He went back to Australia. I'm sure they're delighted. And he has started the whistleblowing program at New Advice Centre as part of the Human Rights Law Centre in Australia, and is one of WIN's newest members. So very delighted to have him here. And Devine, who many of you will know if you're involved in the whistleblower protection world at all, who's been legal director at the Government Accountability Project since 1979, I think. It was started in 77. And he's assisted over 8,000 whistleblowers, and as put in his biography, he's not lost a case since 2006, which is pretty damn good for whistleblowing. But he's also very much a leader internationally in talking about whistleblowing, explaining the issues, and working on whistleblower laws around the world. So I'm really delighted to have these four panelists. And I thought, as I said, Robert, in starting with you, you are now of counsel in the London office of Gibson, Dunn and Crutcher, and you're a member of the firm's dispute resolution practice group. And as I mentioned, he is former president of the European Court of Human Rights. He's also a visiting professor at the University of Oxford for the 2023 academic year, and a professor of law at the University of Iceland. I missed that earlier. And he is an honorary bencher of the Middle Temple. So I'm very pleased to welcome Robert, and if you would like to take, each of you will take sort of 5 minutes to give your views from your experience of what's been happening around the world, and with you, Robert, what's been happening in Europe.
Thank you very much indeed, Anna. I hope everyone hears me in the room. It's a great pleasure to be here, and I would like to use my 5 minutes to just say a few words about the Halle judgment, and I have to do that by first making clear that I speak in a bit of an awkward position on that case, since I was the president of the court in that case, and of course, therefore, am fully responsible for the court's judgments in all respects. I was in the majority, and have to speak about it in those terms, and I hope that is understood. And secondly, I would like to say a few words about the context of that case, also taking account of developments in the European Union field when it comes to whistleblower protection, which you've been talking about this morning. So the Halle case is sort of the last landmark case in a series of cases in the court, going back to the famous case of Guja versus Moldova, which all whistleblower practitioners will know of. The case arises out of the so-called LuxLeaks scandal, or the LuxLeaks issue that arose in Luxembourg. Our applicant, Raphaël Halle, he was a PricewaterhouseCoopers employee who handed over 14 tax returns by multinational companies' clients to a journalist. He was found, ultimately, he was criminally convicted at national level for breaches of national law. Was not given whistleblower status, mainly due to the fact, and as I will come to, that he was not the first to provide this information, but came later in the day with extra information into a sort of a continuing discussion on the issue of taxation of multinational companies in Luxembourg. So the National Court, the Court of Appeal, although accepting that the information that Mr. Halle had made public or had given to a journalist was, and I quote, alarming and scandalous. However, the Court of Appeal made clear that this information did not constitute essential or fundamentally new information. Now, at chamber level, in the chamber of 7 judges, the court did not find a violation, did not consider that Mr. Halle's freedom of expression had been violated, but the case was then referred to the Grand Chamber. And I think the main issue there was the conceptual limitation by the National Court of Appeal of the concept of public interest as being one which did not include new information in a continuing sequence of information brought into the public light from a confidential source. Now, the Grand Chamber, and I don't have time to go, you've probably all read this judgment. There are a couple of points that I would just like to put into context here. The court did again reconfirm the 6 Guja criteria, which are the benchmark criteria for the evaluation of the balance between freedom of expression and potential harms that are caused by whistleblower dissemination. Let me very quickly go through them. That's 1, the channel for disclosure. Number 2, the public interest assessment, which I will come to again, the authenticity of the information, whether the whistleblower acts in good faith. 5, what is the level of damage to the employer, and an assessment of whether such damage outweighs the public interest, and finally the sanction imposed. And I just want to, in my 2 minutes that I have left, say a few words about point 2, the public interest, and point 6, the nature of the sanction. Now,
Okay. Sorry, Robert, we lost you for a minute. Can you just, you started, yeah, can you just go back about 60 seconds?
Yeah, so the 2 issues that I'd want to discuss is, 1, the conceptual framing of the public interest that needs to be assessed under Article 10, the freedom of expression provision after ALE, and secondly, the nature of the sanction, which I think is important also from the perspective of EU whistleblower protection. So the public interest issue was one which had not been fully clarified in the court's case law. And what the court does in ALE, am I still there?
Yep, you are.
Okay. What the court does is, the court says that the range of information of public interest which may justify whistleblowing, that is covered by Article 10, includes the reporting by an employee of unlawful acts, practices or conduct in the workplace, or, and this is the important or of acts, practices or conduct which, although legal, are reprehensible. Now this, we can say addition, this qualification is what divided some of our colleagues in the court. Because unlawful acts are not as such, that has really not been debated in whistleblower doctrine, that they are the main parameters of, or the main conceptual basis for whistleblowing as such. But it is the addition that an act can be legal, but it can remain within the public interest if certain qualifications are met. And I just want to contrast this before I stop with the definition of what constitutes a breach under Article 5.1 of the EU Whistleblower Directive. Because there is also a distinction made between unlawful acts or omissions, but there is also a second prong to that element, which are acts that defeat the object or purpose of the rules in union acts. And we, of course, as you can see from the judgment does refer to and has a clear overview of the EU Whistleblower Directive. And now I think for the future, there needs to be somewhat of a reconciliation between those 2 normative frameworks of law. The final point that I would make in this first round is Mr. Ale was criminally convicted. And I think that's a significantly important element in this regard. The court, the European Court of Human Rights, usually does not take it lightly when expressive activity is sanctioned by virtue of criminal law. And I think that was also an important part in the overall assessment by the court. So these are sort of my preliminary remarks, Anna, and of course, willing to take questions.
Thank you very much, Robert. The other thing I just wanted to mention, obviously all of the cases before the court are where people have publicly disclosed information. And secondly, we're talking about freedom of expression, but we're also talking about the public's right to know, which I think for all of us in the whistleblowing field, that makes a lot of sense. It really isn't always, what we don't want is people's opinions and their right to freedom of speech to be unnecessarily curtailed. But also this is very much in the whistleblowing sphere, is about the public's right to know what's going on. So thank you so much, Robert. Pusetso, are you there? I might just leave you for a minute to get your feet, but we wanted to turn to you next. So I will start maybe with, now have we lost Kieran? So Tom,
I'm here. No, I'm here.
Oh, you're all there. Thank you. I just can't tell because there's someone else up there, Philippos. Okay, so Pusetso, maybe we can start with you if you're fine, because I thought it was really interesting for you to go next with the human rights and freedom of expression point, and what you have found and what's been happening in South Africa. Are you there? Pusetso, are you there?
Just give me a minute. Maybe you can go ahead with Kieran.
Okay, that's fine. Kieran, the Australian situation. You've just set up this new whistleblowing advice service, and there's been a number of important cases. So we're going to go to you. Sorry for these strange directions to the people in charge of technology. But if we could, can we go to Kieran?
Hi, everyone.
We can't see. There you are. Great.
Hi, everyone. Great to be joining you today. Sorry, it's late in Australia. I wish I was in London with you, my former city that I love very much, but instead coming to you from Australia, from Canberra, from the Ngunnawal land, the First Nations owners of this land. Australia was once a world leader in protecting whistleblowers. Queensland, one of the Australian states, was second only to the United States in passing standalone whistleblower protections in the early 1990s. Other Australian states then followed, and soon every jurisdiction in Australia had whistleblower protection. So we once led the world. Unfortunately, we have since rapidly fallen behind. That is so even though our laws remain reasonably strong by global standards. Our public sector whistleblowing framework was enacted in 2013, is still considered to be relatively robust on paper. We've had a comprehensive overhaul of our private sector whistleblowing in 2019, also relatively robust and often used and cited as a model for other jurisdictions. The problem is those laws aren't working in practice. We've done extensive empirical research that shows that the laws are failing. Whistleblowers are continuing to suffer at work. We've had whistleblowers being sued in recent years by their employers for speaking up. And in the last few years, terribly, we've had a number of whistleblowers facing criminal prosecution for blowing the whistle on government wrongdoing. We had a change of government last year. One of those prosecutions was dropped by the incoming government to remain ongoing. And in 6 weeks' time, an army lawyer who blew the whistle on war crimes committed by Australian soldiers in Afghanistan goes on trial. He's the first person on trial in relation to war crimes in Afghanistan. The whistleblower, not an alleged war criminal. I think those cases are the tip of the iceberg of what is unfortunately at the moment a fairly unhappy state of affairs for whistleblowers in Australia. We recently did some research at the Human Rights Law Centre. We looked at every whistleblowing case decided ever in Australia. There's about 80 that we could find. In all of those, there was only one case where a whistleblower was awarded compensation, and that whistleblower received $5,000. So the laws that offered much on paper have not translated into practically accessible and enforceable laws, and a major factor for that, in our view, is the absence of practical support. It's extremely difficult for Australian whistleblowers to get legal support. Unless they have money to afford a private practice lawyer, they can't get pro bono legal assistance, and even if they can afford a lawyer, there are very few lawyers in Australia that specialise in this area. And that was what prompted the Human Rights Law Centre to this year launch our Whistleblowing Project, which is a pro bono legal support service for whistleblowers, building on successful models in other jurisdictions, including Protect, including Government Accountability Project, and so on. We are hoping to turn these paper rights into practice. I mentioned we did this major review that found that no one was winning these cases under the two primary public and private sector laws, which have both been around for over a decade now. There hasn't been a single successful case of any kind. So we really want to begin to draw on the Human Rights Law Centre is fortunate to have incredible pro bono support from law firms and the bar in Australia. Draw on that support, take these cases, win these cases to begin to move the law forward in the right direction. We launched a month ago. We've been inundated with interest. We're rapidly trying to work through our intake at the moment and begin to assist people. One way we did assist recently, a case I'll just briefly touch on before I conclude, is in the other whistleblower prosecution. I mentioned David McBride's case. There's also a tax office employee who blew the whistle on wrongdoing at the tax office in Australia, a guy called Richard Boyle. He's also being prosecuted for speaking up. And he'd relied on the immunity provision in Australian whistleblowing law that provides criminal and civil immunity for whistleblowers. And the trial judge said that he wasn't immune because the criminal offences related to anterior preparatory conduct prior to blowing the whistle, even though it was related to blowing the whistle. You know, for example, taking documents, recording conversations, and so on. The judge said that that wasn't protected by the immunity, adopted an extremely narrow construction of the immunity. Richard Boyle's appealed. The Human Rights Law Centre intervened as a friend of the court and made submissions in favour of a more broad, purposive construction of that immunity, and extremely grateful and thankful to a number of Whistleblowing International Network members who provided input onto the international comparison. That judgment is currently reserved, but I think will have significant implications because it's an issue that arises in a number of countries. So it's a busy time. There's a whole amount of law reform ongoing in Australia right now. Tomorrow morning, I'm appearing before our Parliament to give evidence in relation to one phase of whistleblowing reform. There's talk of establishing a whistleblower protection authority, which I might talk about a bit later because I know that's one of the questions. So there's a lot going on, but unfortunately still the promise, the democratic promise of these laws that we introduced in some cases 30 years ago, still hasn't translated into practical protections for Australian whistleblowers. That's not good enough. It's not good for our democracy. It's not good for our society. And that's why we're doing the work we do to try and make sure these laws can actually work.
Thank you so much, Kieran. One of the things I would say, and I think it's another sort of reason behind the Whistleblowing International Network and WIN, is that whistleblowing is really a citizen's law. It is about people in the workplace often being able to be good citizens and act with integrity. And it does require civil society organizations to be actively engaged. Governments and corporations might understand the value, but they do need to occasionally be reminded. And in my view, it's organizations like the Human Rights Law Centre and Protect and the Government Accountability Project and others around the world, and we'll hear in a minute from Pusetso and PPLAAF, because these are the organizations that keep it on the agenda. It matters to us, we're of the people, and it really matters to society. So I think it's great that you're active and up and running. Congratulations. So Pusetso, can you put on your camera, please? And we can move to you.
Right.
There she is. Hello, welcome.
Hello, thank you.
Great to have you here. Pusetso, if you can put your camera's gone off again. I don't know if that's our end or yours, but if you could keep it on.
Connection, maybe.
It could be your connection. Okay, if it's too bad, then I know that sometimes it's helpful to turn off the camera. But if you can keep it on, that'd be great. And if you'd like to make your short presentation about some of the issues that you have been dealing with and addressing.
All right, I think let me just start with the issue of the freedom of expression. As we've been working with whistleblowers in Southern Africa, and we bringing in the issue of freedom of expression and how important it is to actually be upheld, because whistleblowing is actually a manifestation of freedom of expression, or expressing concerns with about misconduct and corruption is a manifestation of that freedom of expression. But at the center of that discourse in the anti-corruption space and whistleblowing space is actually the question of, is freedom of expression actually going to be so costly that it takes away the right to life? Because that is actually the case in most cases, particularly in South Africa. If we take the recent case of Robert Murray, who was involved with the liquidation of Pusetso in South Africa, who was assassinated, literally murdered with his son. If we take Babita Deokaran's assassination as well, who was, murdered by six hitmen who were recently charged with her murder, you see the importance of this freedom that it actually can take someone's life. And then it brings now the responsibility and the duty of government and of, I guess, of society. What are we willing to really pay to have people blow the whistle and actually practice and exercise their freedom of expression? At the center of lack of protection, I'd like to highlight, just from experiences of dealing with whistleblowers in Southern Africa, that at the center of lack of protection is actually auto-silencing of people. It's actually taking away that freedom of expression. At the center of lack of access to information, because with whistleblowing and whistleblower protection, investigations are very important, and the information that one can access to ensure, to verify whether or not the disclosures are correct, and whether or not misconduct has been commissioned or likely to be commissioned. Without that access, that is also auto-silencing. It's actually denying the freedom of expression to citizens and to employees. But at what cost? If we deny access to information, if we deny access to investigation, then what is the point actually of pushing whistleblowing as an anti-corruption tool, as an accountability tool, as a public interest tool? So we really do need to push more and do more when it comes to ensuring the protection of whistleblowers. And I like the work that the Department of Justice in South Africa has been actually doing in trying to, vamp up and revamp and heighten protective mechanisms when it comes to protecting whistleblowers in South Africa. And that is something that we wish to also extend to other countries in the region, actually in safeguarding and promoting and protecting that freedom of expression, but ensuring that that freedom is actually protected. It will not actually take people's lives. And we also have seen, our legal counsel, Zanele, always uses this phrase that people do not understand how life-ending whistleblowing is in Africa. And sometimes it's not life-ending in terms of being killed. It's actually life-ending in terms of you lose your livelihood, you lose your house, you lose your children move to public schools if they were going to private schools. So is the freedom of expression within whistleblowing discourse that costly? And should it be that costly? But can it actually be protected with the law by putting systems in place and mechanisms in place to ensure that people actually do report and they are protected and they exercise that freedom of expression by expressing the concerns that they see to, one, save companies' money, two, save government's money and public assets for the public interest. So when it comes to the freedom of expression in Southern Africa, mainly, and I think in the continent, probably globally, it has come at a heavy cost. And I think we can do better. And I was actually saying that I like what South Africa is doing with the amendments to the PDA, the Protected Disclosures Act, that with the recommendations that we've gotten from various organizations and departments and countries, benchmarking on different countries' legal framework, they've also opened up for commentary, from civil society on the amendments that they are considering. And that consultative process really showed I'd say, a commitment. I think also the political will from the Department of Justice to have a law that would somewhat protect some of these rights that come with whistleblowing.
Thank you so much, Pusetso. She's said a lot, and this is something that comes up not just in South Africa, but within other countries, and of threats to people's lives and threats perhaps to their families and relatives. And you see in the the EU directive is starting to extend some of the protections to those who facilitate or work with whistleblowers, because they will be caught up. I think the other point, Pusetso, that you're making and that you were talking about, that they're starting to listen to civil society, and it goes right back to, I think, our first panel on accountability. You know, the issue, it can't be that it's worth risking your life if there is going to be no accountability, and nobody would go around telling people that's where the position they should put themselves in. So again, the civil society and the work of PPLAAF and what you do in terms of creating campaigns around the cases, taking on the disclosures so that the whistleblower is not alone as the sole messenger, is absolutely vital, isn't it, for the protection and then the accountability, because it's beyond this one person that people start to respond and the public starts to respond as well as the authorities. Do you want to make a quick comment on that?
Yeah, I mean, I think one of the unfortunate consequences or impact of whistleblowing is that people tend to be ostracized and isolated a lot. And what that does is that it affects their mental health and their well-being. I have seen whistleblowers who, at the young age of 35, 40, are now suffering from tremors and are suffering from short-term memory because of the trauma and the stress that they've gone through. And they always say, I am glad, you know, I'm blessed to have met PPLAAF, because PPLAAF took me out of a dark hole, having someone to talk to, because we also now always veer them, you know, toward counseling or seeing a clinical psychologist. And also just having someone, you know, listen to them and talk to them. It is something that is something more human that at times we think it does not matter, but it matters a lot for most of them. So being there for them, sometimes providing, you know, some funds for toiletries or electricity. You've got no idea how that has been considered very, very helpful, because someone who used to have a job, well-paying job, is now actually literally living, you know, from donations, and PPLAAF tries to sort of like mitigate certain, I guess, discomfort that they're going through.
Yeah. Thank you very much. Just for those of you, PPLAAF is one of the organizations that works across Africa and then works with local organizations and local experts. And Pusetso works for PPLAAF, but is also based in Southern Africa. But there's also other organizations that are coming forward. So there's also the Whistleblowers House in South Africa and other members of associates of WIN, like the Corruption Anonymous in Africmill in Nigeria. So it's great to see this community talking to each other and working together. Thank you so much. We're going to now turn to Tom. Tom Devine, could you please turn on your camera? And this is someone who knows a lot about creating a circle around a whistleblower, having worked at the Government Accountability Project for so long and has been behind many of the laws that have been put in place. Tom, can you hear me?
I can hear you. Can you hear me, Anna?
We can hear you. We can't see you. Can you turn on your camera?
I'll try again. I've been locked out of turning on the camera so far.
Okay. All right. It's one of those. It never completely works. I totally understand. If you want, if you can try again, great. But why don't you just start talking to us about how whistleblowing developed in the US and where you see what's happening now in the future?
That'll be fine. I'm enough of a loudmouth that you don't have to look at me.
I'd like to see you, though.
My assignment was to talk about the United States whistleblower program. And the U.S. has the anti-honor, the honor of being the pioneer for global whistleblower rights. We were the first country to pass a national whistleblower law. We also have the anti-honor of being the most incoherent nation with respect to whistleblowing. Most countries have one or maybe two whistleblower laws. We have 60 just at the federal level. The foundation for these rights was actually the Watergate scandal involving President Nixon's abuses of power. And they were to a significant extent exposed by whistleblowers. From Deep Throat on the anonymous side to many who testified in the Watergate hearings about trying to and the bipartisan merit system for the federal labor force. In response to that, Congress in the Civil Service Reform Act of 1978 included statutory whistleblower protections and really started our movement. That's for the federal level for the civil service employees. On the private sector, we've never been able to get a national consistent law for all aspects of our economy. So there's over 50 individual private sector whistleblower laws in the United States, and no two are alike, just like snowflakes. Anna asked me to cover that, what's happened to the bipartisan mandate in the United States for whistleblower protection. And until 2020, we had one, at least in terms of official decisions. The whistleblower laws almost always passed unanimously. That all changed when whistleblowers were significant witnesses in the Ukraine impeachment hearings of President Trump. And he branded whistleblowers as traitors who should be hung. He doesn't take too well to criticism. And the Republican Party followed him with that rejection. And it's been largely a partisan issue since in the United States, which has been a severe handicap for us activists. The bipartisan mandate is coming back, however, because the Republicans in our Congress are relying on whistleblowers to attack President Biden. Well, I'm not so sure I agree with all of them. I'm appreciating the fact that this is no longer becoming a party line type of issue. As far as the state of rights in the United States, well, our rights were pioneer rights, but in many respects, they become dinosaur rights. The rest of the world is passing us by. The Achilles heel for U.S. whistleblower laws is the lack of effective due process. And that's really for the federal civil service sector. The private sector actually has pretty good due process. They have administrative due process hearings. If those aren't timely completed, they can go to court and have a jury trial. And they do pretty well. They win about a third of their cases. The civil service workers, though, only win about 10% of their cases. And that's because they're limited to administrative hearings that are governed by administrative judges who don't have any judicial independence and almost exclusively come from the ranks of agency lawyers whose careers were built on trying to defeat employee rights. We're fighting very hard to get access to court, but we haven't achieved that yet. And I should say as an aside that the U.S. is in its fourth generation of statutory whistleblower rights. And we're fighting very hard now to get the fifth generation. A second area where the world has passed us by is in burdens of proof. The U.S. was the pioneer for effective formula for the reverse burden of proof structure, which is essential, the rules of the game for what evidence it takes to win or lose. But the European Union Whistle Directive has gone another major step. In the U.S. law, the whistleblower has to show a contributing factor link, some connection or nexus between whistleblowing and what happened to them before the burden of proof shifts. In the EU Whistleblowing Directive, the whistleblower only has to prove that they engaged in protected speech and that a prejudicial event happened. And then the burden of proof shifts to the employer. This is far superior to the U.S. standards. And finally, the U.S. doesn't have any protection beyond workplace harassment. Unlike almost every modern whistleblower law in the last decade, the rights don't protect against civil or criminal liability, slap suits or criminal prosecutions for blowing the whistle. And in our country, you literally can be put in jail for something that you couldn't be fired for. I was asked to also comment about bounties or reward systems and whether or not they're a net positive. Well, in overview, there's no question that the whistleblowers deserve the compensation. No, our whole world is based on commercial activities and making money for providing services to society. And telling the truth about something that's exposes an abuse of power certainly deserves to be compensated and even make a profit as much as selling a television set. However, I'm not a fan of the rewards program for two reasons. One is that in terms of analysis and statistically, the bounty programs have led to an increase in retaliation. Employers are much more suspicious, almost paranoid. If an employee comes and raises an issue with them, that this is just step one in terms of trying to cash in on the problem and take preemptive strikes. The laws have made they've led to an increase in harassment of whistleblowers. Secondly, they've undermined our efforts to get societal solidarity for whistleblowers. That's essential for our movement. And we've put a lot of effort into proving that whistleblowers are profiles in courage who are risking their professional lives to defend society. But corporations have said with the rewards programs, whistleblowers are just modern day Judases who are selling out their peers and biting the hand that feeds them so they can make more money. While that's not true, it's a real obstacle to our having and sustaining the political support that's necessary for whistleblowers to be effective. Finally, I was asked about the challenges to our movement. And the first is to maintain and increase public solidarity. The magic word for whistleblowers to get away with committing the truth and make a difference is solidarity. The fatal word is isolation. At GAP, we don't just do legal cases, we do legal campaigns, matchmaking the whistleblower with all the stakeholders in society who should be benefiting from their knowledge, so that the power dynamics are that society is surrounding the corrupt bureaucracy rather than the corrupt bureaucracy surrounding the whistleblower. Second is if there's going to be commercial whistleblowing, I would recommend substituting the False Claims Act model that's in the United States, where the whistleblower actually files a lawsuit on behalf of the taxpayers, rather than the bounties model where the whistleblower whispers in the government's ear. The False Claims Act model has been more effective in exposing fraud, and it hasn't led to a backlash. The third recommendation that I would have is about the EU Whistleblower Directive. This is a major breakthrough, but it's structured around channels to blow the whistle. And those channels should not be limiting the full scope of freedom of expression. The point of a whistleblower law is the free flow of information to get accurate facts into the right hands for responsible exercises of authority. And if telling the truth is limited to channels, that's going to be cutting off the routine flow of communications that's necessary for problem solving and institutional checks and balances within an organization. The fourth recommendation is to have constant vigilance, monitoring and defending these whistleblower laws. As I said, we're in our fourth generation in the US. We need a fifth generation. Nobody gets it right the first time, and there's inevitable counterattacks even against the best law. This is not an event. This is a permanent struggle against abuses of power. And I'll close by saying probably my most relevant recommendation for you folks is to pass protects legislation to get the second generation after PETA. PETA is one of the weakest whistleblower laws in the world. And protects legislation would systematically achieve all of the provisions of the EU Whistleblower Directive, actually better than any of the EU member nation laws that I've been studying. So it's a worthy project to be rallying around. That's what I have to offer this morning.
Thank you, Tom. That's wonderful. And as usual, full of information and erudite analysis of what's going on in the US. We have exactly 5 minutes. It's never going to be easy with an international panel to cover such a wide area of expertise in different regions. I wouldn't mind going back to Pusetso briefly. When you were mentioning about some of the changes and you've been happy with the Justice Committee's changes or what they're doing, is there anything in particular that is striking you in terms of keeping the focus on the public interest as well in these discussions for a new law or in the reforms? Is there anything in particular like that you've noticed? Are you there, Pusetso? Oh, maybe she's gone.
Oh, sorry, no, I was struggling with unmuting myself. You know, what the Department of Justice has done is take the different sections of the Protected Disclosures Act with recommendations from different organizations, including PLAAF. I think PLAAF has sent 3 pages of recommendations, and most of them are in that document. Was to look at how do we make protection whistleblower centered, and I think that's what the DOJ is doing. From just even looking at the occupational detriment itself, and how now they are actually going to consider maybe instead of calling it occupational detriment, looking at calling it detrimental action, because then in that way the protection then will be off, but it's the PDA will widen a bit the protection for it to also include people that are not just in the employer and employee relationship. So it's looking also at qualifying the issue of disclosures to ensure that should any loophole in the legal framework be used by the accused or those who have corrupted misconduct in supervisory positions wanting to retaliate, some of these loopholes can actually be excluded, or those gaps actually be filled in. There's also just one particular issue when it comes to qualifying disclosures that we highlighted as part that when we include the issue of national security, or when we exclude disclosures relating to national security, we actually also are abetting abuses of power in a way by certain state agencies and essentially stunting the purpose of the PDA itself. But I think grosso modo, in essentially the regimes, the proposed reforms are actually for public interest. And I like the fact that they are trying to make them whistleblower protection centered. And yeah, it's like about 2 pages is a table that summarizes some of the issues that we as civil society are really, really concerned with. And to see that being regarded and considered and put out to the public by the Department of Justice, I thought was a right, was a call in the right direction by the Ministry of Justice.
That's great. I wanted to just give one last word to Robert, because you mentioned the national security piece there. And I know that Kieran's dealing with national security cases in Australia. But Robert, do you want to just make a comment on this? Sometimes it's used as a blanket exception in some of the laws that we've seen, and that some of the countries are saying if it's got anything to do with national security, you can't be protected. And that's obviously not exactly the approach of the European Court of Human Rights. Do you want to make a comment? And then we will wrap up.
Yes, I mean, I think it is true that the European Convention on Human Rights always requires a balancing exercise to be performed. So I think, as you say, Anna, there are no absolute prohibitions in the sense of no freedom of expression guaranteed in a particular factual context. But it is the case, I think I can safely say, that if there is dissemination of information which would constitute a violation of national security laws on confidentiality, the balancing exercise becomes, we'll have to take that into account. So if you look at the way in which the criteria in Halle versus Luxembourg are reformulated or clarified based on the Guja criteria, we have a particular section in that judgment which talks about the nature of the confidentiality breach in question, which can have quite a significant impact on the freedom of expression analysis. So bottom line, as you say, it's not a binary, it's not a black and white issue. It needs to be dealt with on the facts.
I'm out of time, and thank you very much for attending. Our panelists from around the world, some who got up very early, some who stayed up very late. Yeah, thank you so much, all of you.